In our continuing series talking about the pandemic and how it affects workers' rights, we're talking with Peter Moran, an attorney at Pellegrini, Seeley, Ryan, and Blakesley. Good morning, Peter.
Good morning, Adam.
I know with a lot of people starting to go back to work, childcare is a big deal because that has now been closed for the length of our pandemic as well. Will stay closed at least through the end of June. What kind of programs are available to families to help deal with this as people start going back to work or are asked to go back to work?
Well, Adam, there is some good news on that front. Many people are familiar with the concept of the Family Medical Leave Act, and that is a federal program that has been around for quite some time, which in circumstances like this, where someone has to take care of a family member, be it a child, be it an elderly parent, or has some other medical issue of their own, an employer is required to hold the job open for 12 weeks. There's essentially a 12-week period. But that is a situation which is not paid leave. That is simply the holding open of the job for 12 weeks. What the federal government has done in response to COVID is they have passed something called the Families First Coronavirus Response Act. And what that has done is created the same 12-week period in two sets of laws that come together, whereby if one needs to care for a child because either the school is closed, and we know all the schools are closed at this point and are unlikely to reopen, certainly in Massachusetts,
Right.
Or a child care center closes due to COVID. Under those circumstances, the parent who has to take care of that child is entitled to under two separate schemes, first 2 weeks under one part of the act and then 10 weeks under the other part of the act, at a rate of 2/3 of one's usual wage. That individual taking care of that child is entitled to 12 weeks of benefits. It is a family medical leave, but it is paid. And I think that has allowed a number of parents to continue their livelihood and obviously continue to keep their jobs, which they hope to go back to at the end of this period of time. There is one other concept as well. I'll just mention one of the categories here also involves someone who actually has the virus himself. And under those circumstances, the first 2 weeks are payable at 100% of the rate. It's not a care situation, it's an individual with a virus themselves. But in the case of family care, for those reasons, with respect to COVID, closing schools and closing entities that take care of kids, it ends up being a 12-week period at 2/3 of actual wage.
And how do people go about applying for that? How do they get access to that program?
Essentially, the best way to get access to the program is to request the paid leave from one's manager through the employer or human resources manager, whoever is in charge of payments and of scheduling of hours, that kind of thing. So preferably, it would make sense to put it in writing, explaining that in fact the facility or the school is closed and that the parent has a need to take care of the child and that the school has closed because of COVID. And under those circumstances, the entity, the employer, has an obligation to grant this leave.
And the employer does the paperwork?
The employer does the paperwork as opposed to, for example, filing for unemployment. Correct. The unemployment, elsewhere in our series, people will talk about the changes to unemployment relative to COVID. But in this instance, it is through the employer because the employer is the entity that has to be without this worker for the period of time mandated by the statute.
Terrific. And I know that people can also get more information on the PSRB website at psrblaw.com. Peter Moran from PSRB, thank you so much.
Thank you, Adam.